Governor Bart Buxton will be running this examination. I am currently waiting for him to come back into the courtroom.
This one's gonna run?
Yes, Your Honor.
Okay, sounds good. We'll call it when he comes back.
If you want to proceed with the sentencing of Elise Cooper, I'm able to do that.
Somebody was something to proceed. On the record in the matter of the state of Michigan versus David Brown. This is 26-0261. Is David Brown here? Are you David Brown? Okay, Mr. Brown, who's prosecutor on this one?
EPA Burt Buxton on behalf of people state of Michigan, Your Honor.
Okay, Mr. Brown was scheduled for an exam today, but I said we would treat it as another probable cause conference. Because you were trying to meet with some attorneys to see if we could secure representation. Right, have you been able to do that?
Okay, we spoke a few days ago, and he asked that like an adjournment for the preliminary examination.
Who's we?
My attorney, Eric J. Shepherd,
Okay, so you've paid to retain him?
partial payment.
And Mr. Shepherd asked for an adjournment, or is that for you to continue the payment
Yes,
retention process?
he asked for adjournment just because I had a partial payment for my representation. Yes, if I would waive my rights to have a preliminary examination within 21 days. Did my arrangement.
So he did address the 21 days, which I was going to ask you first. You do have the right to have the exam within 21 days of the date that you are arraigned, but due to you not yet having counsel retained fully on this, because we've not received an appearance, you're willing to waive the 21-day timeline so we can reset this?
March 26th at 9.
March 26th at 9 a.m., okay? Do you have any questions at this time? I'm gonna get you a notice to appear. You can let Mr. Shepherd know as well, because we don't know what his calendar is, and if that date's a conflict, he could just email the staff with the prosecutor to get a new date, okay? Once he's filed an appearance. Any additional matters for the record?
Not from people, Your Honor.
Okay, you're all set for today. We'll get you a notice, okay? Okay, I saw Mr. Sart's, Willie Smith, the APA is going to nolly that.
That is correct, Your Honor.
Are you gonna, can you waive his appearance for this purpose?
Yes, please, Your Honor.
State of Michigan versus Willie Smith, 25-03738 appearance.
Good morning, Your Honor. EPA Burt Buxton on behalf of people state of Michigan.
Good morning, Your Honor. Jacob Sarge, the fourth Assistant Public Defender here on behalf of Willie Smith Senior. I will waive his appearance for this morning's proceedings. Thank you.
Okay, so today was the date that was scheduled for a examination. It says that the people are nollying this because it was victim, I was gonna say we do have something from the victim recantation and improper venue, that's correct?
Correct, Your Honor. So we will be reissuing in the proper venue for the gun charges in regard to this case, just so the court is aware. That'll be in 55th District Court, however.
Okay, and Mr. Sarks can advise Mr. Smith if he hasn't already done that.
Yeah, absolutely, Your Honor. I will take care of that right now.
Very good. Any additional matters for the record?
No, Your Honor, thank you.
I would just like to have a copy of the nollie for Mr. Smith, Your Honor.
Thank you.
Thank you.
Thank you. Ryan George Arnhem.
Correct, Your Honor.
State of Michigan versus Jason Walker, 25-02129. Appearance, please.
Good morning, Your Honor. AP Burt Buxton on behalf of the people, state of Michigan.
No, Fred Blackman on behalf of Mr. Walker, you saying, all right, for you.
Okay. Let's see, this is a matter scheduled today for preliminary examination. How are we proceeding?
Your Honor, after talking to Attorney Blackman, it is my understanding that the defendant wishes to unconditionally waive his right to preliminary examination to bind the case over to circuit court. And if that is the case, the people would have no objection and would unconditionally waive as well.
That's correct.
Is there an offer?
But not at this time, Your Honor. Further negotiations will continue in circuit court.
Okay, Mr. Walker, you understand that you have the right to have a preliminary examination on this matter where you're being charged with assault with intent to murder, carrying a concealed weapon, which are serious felonies. You understand that? And you have the right to have a preliminary examination here in the district court. At the time of that exam, you have the right to require the prosecutor establish if they have sufficient probable cause that the felonies alleged were committed, and the probable cause sufficient to charge you as the person who allegedly committed. You understand that? You wish to unconditionally waive your right to have an examination? Okay, so that means this matter will be bound over. There will be no proofs put on at this stage to establish probable cause, correct? Is anyone coercing you to waive your exam? Any promises if you waive your exam? Okay, your bind over date's gonna be February 25th. That's the date the circuit court's going to receive this file, not a date that you need to appear in circuit court, okay?
Sorry, ma'am, I couldn't hear you. Can you repeat that?
Your bind over date, which is the date we send this case to the next court, is going to be February 25th. You do not need to appear in the court for the circuit court on that date, okay? Okay?
Okay.
Your next court date will then be set in a trial. Your attorney will be made aware of that, so you'll remain in contact with him, okay?
Yes, ma'am.
If you have any questions so far?
No, ma'am.
Bond was set at $100,000 cash surety with GPS tether. That will continue. Any additional matters for the record?
No, Your Honor. Thank you.
No further than that.
Thank you. On the record in the matter of the state of Michigan versus Dane Austin 26-00232. Appearance, please.
Anna Buckingham on behalf of the people requesting under 8.120 to practice under supervision of APA Bart Buxton.
And Jacob Ryan, on behalf of Mr. Alston, who's present to my right.
Okay, Mr. Austin is present today. Let's see. This is the same exact plea that I tried last week.
No, Your Honor, we adjusted it to remove the breaking and entering charge and instead to plead to attempted resistive struck count 1 and 2.
Okay, so you can dismiss count 3. And so the plea was rejected last week because I could not get a factual basis. And during that time, you, sir, advised the court that you didn't do it. You remember that?
Yes, ma'am.
Okay. And so are you now saying that you did resist and obstruct an officer or
Yes.
attempt to?
Yes, ma'am.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, I do.
Okay, and you understand your rights, which is your right to continue to trial and your right to the presumption that you're innocent until proven guilty, the right to have the prosecutor prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt, correct?
Yes, ma'am.
And is anyone threatening you to get you to enter a guilty plea to the amended counts 1 and 2 of attempted resisting obstructing officers?
No, ma'am.
Any promises being made to you to get you to enter a guilty plea?
No, ma'am.
Okay, and so as to the attempted resisting obstructing officer in count 1 and 2, how do you plead?
Guilty.
Tell me what you did to make you guilty of that.
I told him,
Excuse me?
I told him that I wasn't gonna enter the car.
You told the officer that you wasn't gonna enter the car?
Yes, ma'am.
What car?
The squad.
Okay, so you, on or about the date of January 25th, 2026, was at the area of 1128 West Washtenaw.
Yes, ma'am.
Is that in Lansing,
Yes, ma'am.
Ingham County?
Yes, ma'am.
And so you had some interaction with law enforcement?
Yes, ma'am.
Why is that?
Allegedly said that I had got broken into a car.
Okay, and so they stopped you, they asked you some questions?
Sort of, kind of, but they just kind of like, they just really just accused me of doing it.
Okay, and so, and you told them you didn't do it?
Yes, ma'am.
And then they told you to get in their squad car?
Yes, ma'am.
Did they put cuffs on you at all?
Yes, ma'am.
Okay, so you were cuffed first.
Yes.
Okay, well, as they were cuffing you, did you resist at all?
I don't think I did.
Well,
I was slipping and sliding in the snow because I was trying to tell them that I didn't do it. We had
You
the
were
wrong person.
slipping and sliding in the snow. So you were standing on snow when this took place?
Yes, ma'am.
So when you say slipping and sliding in the snow, what do you mean?
Like, they were cuffing me and I was telling them I didn't do it. You got the wrong person. I didn't do it. I didn't do it. And then they said, just get in the car, just get in the car. And I told them no.
Okay, so due to the slipping, was your arms behind your back at the time?
They were cuffed.
Okay, were they struggling to put cuffs on you because of the slipping?
No, ma'am.
Okay, and so after you were cuffed, and you say you're cuffed without any incident, correct?
Yes, ma'am.
And then they tried to put you into the back of the squad car and you told them no?
Yes.
And how many, it was 2 officers?
No, it was more than that.
Okay. Okay, and so you told them, no, you weren't gonna get inside the vehicle because you didn't do it?
Yes, ma'am.
And then what happened?
And then they sat me in the car and then I was trying to explain to them that it wasn't me, it wasn't me, it wasn't me. And then that's when it got really physical. And then that's when the officers started dragging me by my throat and pulling me by my coat.
Okay, so you didn't just tell them you weren't gonna get in the car, you refused to get in the car.
I sat right there and I was in the car, like sitting down on the car, like within the door, like sitting in the car. And then I told them, they said, they were telling me, get in the car, get in the car. And I said, I'm not getting in the car because I didn't do it.
It's not just about what you said, you didn't get in the car. If you said that's when it got physical, they had to physically put you in the car?
They pulled me.
They had to physically pull you in the car?
the officer went around the other side when I was in the car. And pulled me.
Because you refused to get in the car.
Yes, ma'am.
Thank you. Any additional factual basis?
The people are satisfied.
Defense is satisfied.
What is also satisfied with the factual basis? I'll accept your plea. Find your plea to be freely, voluntarily, and intelligently made. How long has he been in custody since this incident?
Yes, Your Honor, since the 24th, I believe, of January.
Credit time, sir. Please also.
You,
Thank you. Are you ready on Beard?
Yes, Your Honor.
Yes.
State of Michigan versus Schumer Beard, 26-00262. Appearance, please.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Gary Robinson, Assistant Public Defender for Mr. Beard.
Okay, today was the date that was scheduled for a preliminary examination. This is for, it's like carry concealed weapon in possession by prohibited persons. Are we ready to proceed?
Yes, Your Honor, the people are ready to proceed at this time.
Any preliminary matters?
We would just ask for the rules of sequestration, Judge.
Sequestration is ordered. How many witnesses are you calling?
We have two that are currently here, Your Honor.
Officer witnesses?
Two officer witnesses.
You call your first witness.
Thank you, Your Honor. The people call Trooper David Paulson to the stand. Trooper Paul.
yeah. You didn't pick anybody else.
We're doing it again, so I would say no.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
You can have a seat. You can state your first and last name and spell both.
David Hoff, David, Hoff, Poff.
You can proceed.
Thank you, Your Honor. Trooper Paul, how are you employed?
With Michigan State Police,
How long have you been employed with the Michigan State Police?
almost 4 years.
Were you working on January 27th of 2026?
I was.
In what capacity?
I was working with the Secured Cities Partnership.
Were you-
Border Patrol.
Understood, thank you. Were you working with another Michigan State Police trooper at the time?
I was Trooper Morgan.
Did you conduct a traffic stop on a Shunmer Beer?
We did.
Is that individual here in the courtroom right now?
He is.
Could you please identify him by a piece of clothing that he's wearing?
I believe he's wearing a KFC polo.
Your Honor, may the record reflect that witnesses identified the defendant.
Any objection?
No objection for purposes of preliminary scene.
Noted.
Thank you. Trooper, where did this traffic stop occur?
Waverly and Jolly.
And what was the reason for the stop?
Window tint. Illegal window tint.
Were you the driver or was Trooper Morgan the driver?
Trooper Morgan was the driver.
And you said that a traffic stop was conducted. Did Trooper Morgan put on the sirens in the vehicle?
Yes, he put on the lights and sirens after the vehicle was slow to stop.
And you say slow to stop. Can you give a little more information in regards to that?
We passed multiple businesses, I believe, church, quality, QD, convenience store, and then a couple other businesses prior to stopping, and then I believe we passed the street as well. The vehicle continued, tapped on its brakes, and then when he activated the sirens, the vehicle eventually pulled over. So it took longer than the usual traffic stop to pull over.
Understood. Thank you. Do you know if there was a passenger in the car at the time?
There was, I do not remember his name. There was 2 passengers. There was a female and a male.
Was the male passenger, did the male passenger have some type of criminal history to your knowledge?
He did. Yeah.
Objection calls for hearsay?
Are you talking about the lien information?
Yes.
Your Honor, that's records of regularly conducted business. That's,
Objection to lien.
thank you. What was that history that you were made aware of?
He was on probation for a gun charge.
Was there a search of the car done?
Yes.
And what was the reason that the search was done in the vehicle?
There's a multitude. Totality of the circumstances gave us probable cause to search the vehicle.
And was there, what was found inside of the vehicle?
A loaded pistol.
And where was that loaded pistol found?
I did not search the car, so I do not recall where
Understood.
it was located.
Did you end up conducting a lien search of the gun?
I believe it was me that, I believe that I did the lien check on the gun.
Okay. What was the results of the lien check on that gun?
It was stolen.
Thank you. Was Mr. Beard ultimately arrested as a result of this search?
Yes.
Thank you. Nothing additional, Your Honor.
Cross-examination.
Yes, Your Honor. Trooper Puff, you stated that you conducted a traffic stop on Mr. Beard in the area of Waverly and Jolly Road, correct?
That is correct.
And that's because you noticed that he had window tint on one of his windows?
Yes.
And so when you attempted to pull him over, you did not initially turn on sirens. It was just the lights, correct?
Trooper Morgan did. He was driving that day, but yes, he initially turned on his lights and later his sirens.
Okay. And so he was a little slow to stop at that point in time. And you saw him sort of, I guess, check his brakes by the brake lights like briefly coming on and off. Is that correct?
That is correct.
Okay. And then when Trooper Morgan activated his sirens, Mr. Beard finally pulled over. Is that correct?
Yeah, not right away, but it was shortly after he turned on his siren that he pulled over.
But he didn't speed off, correct?
So, I mean, he stopped.
I'm confused. Let's stop right there real quick. She said that when the question originally was that once the silence was activated, the defendant immediately stopped. You said no, but then you said shortly after. So I need some clarification as to what shortly after means.
I'm not sure exactly how far he went after the sirens were activated, but it wasn't.
It wasn't an immediate pullover
Yeah, it wasn't
after
like
the sirens.
he heard the sirens, the brake lights came on, and then he pulled over. It was still
Okay,
sometime after.
thank you.
Yeah,
But he didn't drive like a mile down the road, correct?
no, I don't think it was a mile. No.
And it was pretty quick that he pulled over, like less than a minute.
I don't know the time frame, but I know it was longer than what an average traffic stop, it would take an average traffic stop for someone to pull over. During a normal traffic stop, a trooper won't usually turn on his sirens unless it's longer than the time it usually takes someone to pull over.
But Trooper Morgan did turn on his sirens and he pulled over, correct?
Eventually, yes.
Okay, and so the car stopped and Mr. Beard was asked to get out of the vehicle, is that correct?
Yes, Trooper Morgan asked him to get out of the vehicle.
Okay, and Mr. Beard did get out of the vehicle, correct?
Yep.
And then Mr. Beard was searched, his person was searched, is that correct?
I'm not, I didn't search him, so I'm not sure.
Did you witness if he was searched or not?
No, I was at the passenger side, so I'm not sure. I'm sure I did see him eventually. I'm not sure the circumstances of that search, so.
So your only interaction really with the stop was with the front passenger, is that correct?
That is correct. And rear passenger as well.
Okay, so the passengers of the vehicle, you didn't have any interaction with Mr. Beard himself?
Very little.
Was that during the stop or after the stop? That you had interaction with Mr. Beard?
I mean, we transported him to jail. I was in the car when he transported him to jail, so I guess.
So after the stop, after he was arrested, correct?
Correct.
I have nothing further.
Redirect.
Real briefly, Your Honor. Trooper, you had mentioned that the stop wasn't immediate and that you had passed by some businesses. Were there parking lots for those businesses?
Yes.
So there were multiple places that the defendant could have gotten off on the road?
Correct. Yep.
Thank you. Nothing additional, Your Honor.
I had some questions. I don't know the reason for the stop still. Totality of circumstances is not a reason for a stop. I need to know what the reason for the stop. What was the totality of circumstances?
Are you talking about the search, Your Honor?
The search, correct.
And I would be calling Trooper Morgan to go into more information in regard to those totalities.
He said that it was totality of circumstances. Do you know why there was a stop or search, that is?
Are you asking why there was?
Yeah, you said,
Stop.
you were asked by the prosecutor if there was a search done in the vehicle. You said yes, and he asked you why. You said totality of circumstances.
I was notified by Trooper Morgan that he had probable cause to search the vehicle.
Okay, so do you know what the probable cause to search was?
Based on,
Do you know?
not from my personal knowledge, no.
Oh, okay, thank you. That's all I need to know.
Thank you. May this witness be
Yes,
excused?
there's a sequestration order, so you can't talk about your testimony with your counsel. Thank you.
Your Honor, at this point, the people would call Trooper Andrew Morgan.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
You can have a seat. You can state your first and last name. Bravo.
Trooper Andrew Morgan, ANDRAWMORGAN.
Proceed, counsel.
Thank you, Your Honor. Trooper Morgan, how are you employed?
The Michigan State Police,
How long have you been working with the Michigan State Police?
almost 5 years.
Were you working on January 27th of 2026?
Yes.
In what capacity?
I'm assigned to the Secured Cities Partnership in the city of Lansing.
Did you conduct a traffic stop on a Sunmer Beard?
Yes, sir.
Is Mr. Beard here in the courtroom right now?
Yes.
Could you please identify him by a piece of clothing that he's wearing?
He's sitting to my left in a black polo shirt.
Your Honor, may the record reflect that the witness has identified the defendant.
Any objection?
Not for purposes of preliminary exam.
Thank you, Your Honor. Trooper Morgan, what was the basis of the stop?
Illegal window tint. I observed illegal window tint on the front passenger window. The tint was covering the entirety of the window.
And were you driving the vehicle at the time?
Yes.
You said the tint was the entirety of the front driver window, you said?
Front passenger.
Front passenger.
And where did the stop ultimately occur?
I initiated the traffic stop at the intersection of Waverly and Jolly, and then the vehicle ended up stopping further south of that past Hartford Road after passing, I believe I counted 5 parking lots and a side road that the vehicle failed to pull over onto, or even just on the side of Waverly Road.
And did you have both your sirens and your lights on at the time?
Yes, I initiated the traffic stop with my lights, and then when the vehicle didn't stop right away, I initiated my sirens multiple times.
Around how long did it take for the defendant to stop after you put on your sirens? If you can?
I don't know exactly how long it was, but like I said, I know we passed, I believe I counted 5 business parking lots and a side road that we had passed that the vehicle failed to either pull into there or just stop on the side.
Did you end up having contact with the defendant?
Yes, I made contact with Mr. Beard at the driver's side of the vehicle.
Did you have him step out of the vehicle?
I did,
And why was that?
because the vehicle was slow to stop when I initiated the traffic stop.
Did you end up having a conversation with the defendant?
I did.
What did you notice while talking to Mr. Beard?
When I initially started the conversation wondering why he didn't pull the vehicle over right away, to which he stated he didn't see my lights and he didn't know I was behind him until I activated my siren, but then told me he had his music up loud and couldn't hear the siren, which was contradicting and made absolutely no sense. I asked him I explained to him that I stopped him at the intersection so that he had an opportunity to pull into the Quality Dairy parking lot or any of those other parking lots to get off of the snowy roadway. And I pointed at Hartford Road, which we had also passed, and asked him why he didn't pull off onto that road. And he just kept saying, well, I was going to, but clearly just did not do it.
you notice anything else unusual about this experience?
Yes, so I go through a typical line of questioning on every traffic stop. Most of it's just for my safety. I ask about narcotics in the vehicle. So when I asked him about if there was any narcotics in the vehicle, he looked me straight in the eye and said, never. I ran down a line of narcotics, to which he had the same answer, looked me straight in the eye and said, never. I asked him if he carries anything for protection, at which time he looked down and away and said, no. So kind of changing his line of answering. Further into the conversation, he was asked if there was any firearms in the vehicle, to which he said there shouldn't be. And in my training and experience, I've seized multiple firearms and narcotics out of vehicles. When people fail to definitively answer the question.
Objection. It calls for expert testimony.
Do you want to respond to the objection?
Your Honor, he's just talking about his knowledge and everyday experience and being a trooper. He's not giving any expert opinion.
I agree. You can give some testimony about what his experience has been in the 4+ years.
Thank you.
Objections overruled.
So yeah, in my time as a trooper, I've seized multiple firearms and narcotics out of vehicles when people fail to definitively answer the question that's asked, specifically when they say there shouldn't be something in there, which my typical response is, well, I know there shouldn't be, but is there? It's a strictly a yes or no question. And that in my training experience, people will do that to separate themselves from said contraband, because then if you find that said contraband, in this case a firearm, they can say, well, I said there shouldn't be one in there. I didn't know.
You had talked about your training and experience in regards to these types of situations. Have you ever noticed anything in regards to your training and experience in regards to someone that's slow to stop?
Yes. So a lot of times in my experience and in my training, you notice people are slow to stop because they are taking time to hide contraband from law enforcement. If they don't have it, you know, if they have it in a spot where when I walk up to their car and I can just see it, they need time to put it somewhere, especially in this case, when we have multiple avenues that he could have stopped and pulled off the roadway, which in my training experience, I also know I'm an understanding person. I know it was, the road conditions weren't the best. That's why I activated my lights at a time that gave him time to pull off the snowy roadway. Mr. Beard failed to do that, in which case, at the end of the day, he could pull over on the side of Waverly Road, and that would be fine, but he didn't fail.
During your initial stop, did you ultimately, I guess before I ask, were there other passengers inside the vehicle?
There was, yes.
Was there an Alan Wiseman inside the vehicle?
Yes, he was the front seat passenger.
Did you end up running lean on Mr. Wiseman?
Somebody did, and the information was relayed to me. I don't know exactly what it was.
And what was that information given to you?
He's on probation for weapons offenses.
After learning all of this and after learning everything that you had just talked about, what did you then do next?
Well, it should also be noted that Mr. Beard admitted that he had prior weapons offenses as well. I ultimately conducted a probable cause search of the vehicle, which first I found a loaded pistol magazine in the center console of the vehicle, which was next to pill bottles with Mr. Beard's name on them, as well as a diabetes test kit, which Mr. Beard admitted to me that he has diabetes. And then I also found a loaded pistol under the driver's seat of the vehicle. And it had the magazine that was inserted into the pistol matched, is identical to the magazine that was in the center console next to the pill bottles with Mr. Beard's name.
What did you do at that point?
Mr. Beard was placed under arrest.
Thank you. Nothing additional, Your Honor.
Last examination.
Trooper Morgan, you stated that you started, you turned on your lights on Waverly and Jolly, is that correct?
Correct.
And then after he didn't stop right away, you then turned on your sirens, correct?
Correct.
Okay. Mr. Beard eventually pulled over soon after Hartford Road, is that what you said?
Yes.
Okay, and that's the next road after Jolly on the intersection of Waverly and Jolly, correct?
I believe so.
Okay. And you stated that there were about 5 businesses that he passed?
Correct.
Okay, between then and Hartford Road, is that correct?
Correct.
But the conditions weren't favorable also, so it was a little snowy out, wasn't it?
Yeah, the road conditions weren't favorable. I don't know if it was snow.
And when you pulled Mr. Beard over, you asked him to step out of the vehicle.
Correct.
He complied with that.
Correct.
Okay, and then you asked to search his person, didn't you?
Correct.
And he said, yes, you can search him, correct?
Correct.
And then you searched his person and you found nothing, correct?
Correct.
Okay. And that's when then you started to ask him about narcotics. Is that correct?
Well, I asked him first why he didn't pull over right away.
Okay, so you asked him about why he didn't pull over, and then you asked him about narcotics, correct?
Correct.
This was after you searched his person and found nothing, correct?
Correct.
And then you stated, you asked him about firearms, correct?
Correct.
And he said shouldn't be.
Correct.
Okay. Now, at this point in time, after Mr. Beard pulled over, well, between when you turned on your lights and sirens and when he pulled over, you didn't notice anything else happening in the car, correct?
As far as what?
Like you just saw him driving, like you didn't see anything else, correct? Did you see anything else in the car?
No, just the 2 other people.
Right, so just people sitting in a car, correct?
Correct.
I have nothing further.
Can you read that?
Just briefly, yes, so the stop, we mentioned the stop occurred at Waverly. Was that in the city of Lansing?
Correct.
Hingham County, state of Michigan? Thank you. Nothing additional, Your Honor.
Thank you, Trooper Morgan.
Thank you.
Additional witnesses.
And no, Your Honor, people rest.
Is the defense calling witnesses today?
No, Your Honor.
Argument.
Yes, Your Honor. In this case, the defendant has been charged with 5 counts, 5 felony counts. The first being carrying a concealed weapon. You know what? I apologize, Your Honor. I had forgotten. I do wish to admit people's proposed exhibit 1 into evidence, which is the judgment of sentence. Thank you. Thank you. So as I had said, count 1 being carrying a concealed weapon, count 2 being possession of a firearm of a prohibited person, count 3 being ammunition possession by a prohibited person, count 4 felony firearm, and count 5 felony firearm. We believe that we have met the elements for all of these and we ask that you bind over. In regards to count one, carrying a concealed weapon, the jury instruction that contains the elements for that charge are 11.1A. Specifically, carrying a concealed weapon in regards to a vehicle. There are three elements. The first is that the pistol was in a vehicle the defendant was in. In your honor, you had heard from Trooper Morgan that on this date, on January 27th of 2026, on Waverly Road in the city of Lansing, Ingham County, state of Michigan, that ultimately, due to multiple reasons, he ended up having probable cause to search a vehicle. Those causes, as you heard from Trooper Morgan, being that the defendant was initially slow to stop, which in his training and experience is typically due to the fact that an individual is attempting to hide contraband prior to the police stop itself. You heard that the defendant showed deception in regards to answering him, in regards to specifically when talking about the firearm. He looked away from the officer and said, "Oh, there could be one inside of the vehicle." And then finally, Your Honor, the defendant had gun charges previously. And additionally, the passenger inside of the car, Mr. Wiseman, was currently on probation for a firearm-related offense, Your Honor. As he was on probation, there is, and ultimately due to all this information, the officer found that there was probable cause to search the vehicle. And inside of that vehicle, he found a 9mm sitting underneath the seats that the defendant was driving. It was sitting in and was ultimately driving the vehicle on. The second is that the defendant knew that the pistol was there. Once again, Your Honor, the defendant's statements made to Trooper Morgan saying, well, there could be, instead of a definitive outright no, as he had stated for the narcotics, shows that the defendant had some knowledge of the pistol. Additionally, Your Honor, due to Trooper Morgan's statements that there was ammo found of the gun inside the center console next to the defendant's diabetes medication, and additionally, that ammo being the same exact ammo for the pistol that was found under the gun, or found inside of the gun, all shows knowledge of the defendant of this pistol.
You
Third,
said the defendant said it could be. I thought he said it shouldn't be.
I think he did say it. You're right, Your Honor. He did say shouldn't be.
Okay.
He did say shouldn't be. Instead of an outright definitive no, as he had stated to the narcotics. And then in element 3, Your Honor, it says the defendant took part in carrying or keeping the pistol inside of the vehicle. Your Honor, if the pistol was inside of the vehicle and the defendant knew about it and there was ammunition next to his diabetes medication inside the center console of the vehicle he was driving, it's clear that he took part in carrying or keeping the pistol inside the vehicle. So we believe we've met this count. In regards to count 2, the possession by a prohibited person of a firearm, there are 2 elements that need to be met unless there is more an argument made as to the length of the crime, Your Honor. There has not been one at this point, so I will just be focusing on the first 2 elements. The first is that the defendant knowingly possessed a firearm in the state of, once again, Your Honor, as I had argued, knowledge of the pistol in the carrying concealed weapon. I would move that argument to this as well. And then number 2, at the time, the defendant was previously convicted of discharge of a firearm from a vehicle and or carrying a concealed weapon. And as you can see in People's Exhibit 1, Your Honor, the admitted certification shows that the defendant had been convicted of this offense. The next count 3, Your Honor, is possession by a prohibited person ammunition. Once again, there are 2 elements unless there is additional argument by defense, and there has not been at this point. First is that the defendant knowingly possessed ammunition in the state. Once again, you heard from Trooper Morgan that ammunition was found inside of the center console of the vehicle next to his diabetes medication. And that ammunition was the same exact ammunition that was found inside of the gun. Secondly, at the time, the defendant was previously convicted of, once again, discharge of a firearm from a vehicle and or carrying a concealed weapon. Once again, that could be seen in People's Exhibit 1. Counts 4 and 5, Your Honor, are both felony firearm. Those felony firearms being attached to the possession by a prohibited person of the firearm in count 2, and the possession by prohibited person of ammunition in count 3 for the fifth count. Those elements being that the defendant had committed the crime of either possession by a prohibited person of firearm or possession of a prohibited person of ammunition for count 4 and 5 respectively, and I've already argued that. And then in regard to the second element, Your Honor, is that at the time the defendant committed the crime, he knowingly carried or possessed a firearm. Once again, Your Honor, I have argued the knowledge in regards to both the firearm as well as the ammunition. So I believe we have met that as well. So I would ask that you bind over on all these counts. Thank you.
Yes, Your Honor. I'll start off with some case law. Your Honor, in Knowles v. Iowa, that's 525 US 113. It's a SCOTUS case. That case stated that it prohibits police from searching a vehicle which was stopped for a minor traffic offense without additional probable cause. In 2015, the Supreme Court also expanded on that rule in US v. Rodriguez. That's 575 US 348. Extending a traffic stop beyond the time necessary to perform said traffic stop, absent additional circumstances, is not enough. That was dealing with the dog sniff. In People versus Kavanaugh, that's 320 Mishap 293. It's a 2017 case. It discusses the considerations of, I guess, someone's demeanor during a traffic stop, specifically nervousness. Stating, moreover, many courts have given little weight to considerations of nervousness during a traffic stop. Stating that nervousness is, or see United States versus Richardson, stating that nervousness is an unreliable indicator, especially in the context of a traffic stop, and noting that many citizens become nervous during a traffic stop, even when they have nothing to hide or fear. United States versus Simpson, recognizing that nervousness is of limited value in determining whether reasonable suspicion exists because most citizens, exhibit signs of nervousness when confronted by law enforcement, whether they are innocent or guilty, and absent significant knowledge of a person. It is difficult even for a skilled police officer to evaluate whether a person is acting normally for them or nervously. That case also specifically deals with similar circumstances to this one. The defendant in that case was pulled over, did not initially stop right away, but eventually did stop. And then they did find something in the car after a minor traffic violation, was pulled over for a minor traffic violation. They looked at the fact that that defendant in that case couldn't produce registration for the title of the vehicle that he said he only recently purchased, that he also stated that the defendant wanted to sit with the door open in the car, and he thought this was unusual and normally people don't do this. So that would be another reason that the officer pointed to probable cause to search. But there was really no additional reasons to articulate the basis of conclusion of suspicious behavior. And in this case, I think that's the same. Here we have Mr. Beard, who was pulled over for illegal window tint, which is a minor traffic violation. He was asked to get out of the car for the minor traffic violation. He did that. He was searched. His person was searched. They found nothing during that. I mean, at that point in time, that traffic stop should have been ended. He should have been cited or given a warning and allowed to go. They had no additional reason to search the vehicle at this time. They stated that he was a little bit slow to stop. He wasn't charged with fleeing and eluding in this case. He didn't increase his speed. He braked. He stated that he didn't initially hear the sirens, but soonish after he heard the sirens, he did pull over. He wasn't trying to run. He offered, when the officers told him to get out of the vehicle and asked to search him, he complied with that. When they asked him about narcotics, he said no. And the question about there shouldn't be, or if there's any firearms in the car, there shouldn't be, I don't think shows any sort of deceptive, I guess, deceptive behavior on Mr. Beard's part. He knew that there were passengers in the car. I don't think it's reasonable to assume that you're searching your passengers of your vehicle before you get into a car. So he stated that there shouldn't be. The car was still searched based on probable cause. But I also want to point out that I think in this case, it was really just a hunch. And a hunch in this case isn't enough. A hunch isn't probable cause. It's not probable cause to search a vehicle. You know, and we see in Terry versus Ohio, that's the, you know, pinnacle decision on probable cause. And it states, however, the constitutional requirement is clear. A hunch is not enough. If a hunch was sufficient to support detention, like the one that occurred in this case, many more unconstitutional detentions would occur. The requirement that law enforcement officers possess more than a hunch is necessary even when a suspect is actually guilty in order to preserve the rights of innocent individuals against unlawful police detentions and searches. So I would argue, Your Honor, that I don't believe that there is probable cause to proceed on these counts based on the fact that the search of the vehicle and the fruits that were conducted of that search was unlawful.
Thank you. Tonight's date scheduled for preliminary examination. The burden is on the prosecutor to establish sufficient probable cause that the felonies, Mr. Beard, that you've been charged with were committed, and then sufficient probable cause that you were the one who committed these felonies. So this is not a trial. They don't have to prove each element beyond a reasonable doubt. They just need to establish that they have more than mere suspicion that these facts or these incidents took place. We have here testimony. I'm not going to get into the first trooper's testimony because it wasn't necessary. We didn't need them. They only needed Officer Morgan because it sounds like the first officer was there. He didn't do the search. He wasn't the one who could explain probable cause. He didn't need it. But we did have Trooper Morgan, who testified that on the date in question, that being on or about January 27th, I believe, 2026, at the or near the area of Waverly and Jolly at the intersection there, which is in the city of Lansing, Union County, state of Michigan, and makes venue in this court appropriate, that the a vehicle was identified and stopped due to a tent violation, which is a minor traffic issue. Trooper Morgan testified that the tent covered the entire front passengers area of the vehicle, that he initially initiated his traffic lights or stoplights, I should say, emergency lights to effectuate a traffic stop. He states that the defendant, or the person he identified in the court as a defendant, that being Mr. Schumer Beard, did not stop after those lights had been activated. Trooper Morgan testified that the sirens had to be activated multiple times before the vehicle that the defendant was operating pulled over. The witness wanted the court to note that there were at least 5 businesses with parking lots that the defendant passed, but it all should be noted that, and I'm not clear because no one ever questioned what the actual weather was, but the roads weren't clear. We know we've been getting a lot of snow in the last couple of weeks, so maybe it was snowing. I don't know. I don't know, again, the road conditions, but it sounds like there were at least 5 businesses or areas that the defendant could have pulled into if he knew he was being pulled over. The trooper asked the defendant multiple times why it took him so long to pull over, to which the trooper believed that the answers were inconsistent. One being that the defendant responded, he didn't see the lights. That's reasonable. The other answer being that he didn't hear the sirens because his music was up loud. That also could be reasonable, or it could be didn't hear it because there were no sirens until he didn't immediately stop. I guess there is some evidentiary value to the testimony of Trooper Hoff, who testified first, and that was that after the sirens were activated, that the defendant did stop shortly thereafter. It's very unclear to the court still what shortly thereafter, but it was less than a mile, I guess, all we can clear up at this point. But there was, at least on cross-examination, I think it was a Hartford Street was the area that he stopped, and that's one street over from Waverly. So we're not talking about a substantial distance. We're not talking about an acceleration in speed. God bless you. It appears, at least from the first trooper's testimony, there was at least some time where, from the time that the lights were activated to this actual stop, that the defendant's vehicle activated their brake lights. So it's understandable why there was no charge of fleeing and eluding under these circumstances. However, the trooper believes that based on his training and experience that typically when people are slow to stop after seeing or traffic light, I should say emergency lights or a siren, that's because they may be trying to hide contraband. We have here where the stop is initiated and the officer or the trooper talks to the defendant and asks the defendant if he could step out of the vehicle to be searched. He was searched. There was nothing found on his person. Trooper Morgan said he asked specifically about narcotics, if there were any narcotics in the vehicle, to which the response the trooper believes was very pointed, very direct. No, never. Eye contact given and a straight answer. The trooper believed that when the next question was asked, that body language and energy shifted. And that's part of the officer's job, is to ascertain if there's a shift in that body language. And he says he asked if there were, if the defendant carried anything for protection, to which the body language allegedly shifted. And the defendant looked, his eyes went from looking straight ahead to looking down. And the next question posed by the trooper to the defendant was whether or not there was any firearms or weapons in the vehicle. And the answer that the defendant allegedly gave was there shouldn't be. The defense is arguing that the officers in this particular case don't have enough to proceed with the search, that it was a traffic stop, a minor traffic violation, and that these answers do not amount to anything more than a hunch as to whether or not there is some crime that they need to further investigate. And I would tend to agree with that. However, there was some information that the defense did not even touch on that came out during the officer's testimony or the trooper's testimony. There was also a question about the defendant's criminal history, and he admitted that he had prior weapons charges. We also have other individuals in the vehicle, one of which is presently on probation for weapons charges. And so when the officer asked a direct question, and the first answer about whether or not there's narcotics is very direct, never. It should also be noted that the trooper did testify that there was actually some narcotics in the vehicle. They just were legal narcotics. He had some prescriptions with his name on it in the vehicle, but he still was very pointed, no, never. But when asked about whether or not there was firearms, it was a shouldn't be. That to me would read that, I don't know. It shouldn't be, but I really don't know. But based on this other information that we have someone with a prior history of weapons charges or violations, and then we have someone in the vehicle who is on probation for weapons, and neither of these individuals likely should have weapons in there. And I asked you if there's weapons in there, and you say you shouldn't, or you don't really know. Well, I think that now we do have probable cause to search the vehicle. So it's for that reason that the court is satisfied that there's sufficient probable cause as to count 1, weapons carrying concealed. Counts 2 and 3, which were weapons and ammunition possession by prohibited person, based on the testimony, as well as People's Exhibit 1, the court is satisfied that there's sufficient probable cause as to counts 2 and 3. Counts 4 and 5 with felony firearm will also be bound over. The bind over date is going to be February 25th. That's the date the circuit court's receiving the file from the district court, not the date that you, sir, need to appear in court. Okay, sir? Your next court date will be a pretrial. Ms. Robinson will be aware of that. Once the circuit court receives the file, you stay in contact with her, okay?
Your Honor, just so it's on the record, there is a habitual fourth offender notice as well. I understand it is not necessary for exam, but I just want to make sure that is put
It's
on.
in the file too.
Okay.
The people did file on January 28th, notice of intent to seek enhanced sentencing as a fourth habitual offender under NCL 769.12. The bond in this matter of 3,010% will continue. Any additional matters for the record?
Not from the people, Your Honor. Thank you.
No, Your Honor.
Thank you. And then Ms. Robinson had someone needs to be sentenced.
Cooper, she's in custody.
Could you be brought up? Downstairs? Oh, sentencing, maybe she was supposed to be put on.
I talked to her this morning, so she's here.
Oh, she's downstairs.
Yeah.
Oh.
And then we're running our game. Yes. We have a competency. What's going on with the Chris Evans?
I think we're running. Okay.
I'm just, there is, for some. That's your client?
It is my client. Judge.
Okay, we can handle that.
Sure.
Okay, on the record, in the matters of the state of Michigan versus Mark Anderson, I have 23-01522, 23-02918, 25-01805, 25-02000, and 25-02492. Appearances, please.
Anna Buckingham on behalf of the people.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mark Anderson, who appears today via Polycom. For what it's worth, I guess just make clear record, I represent him on the felony file only technically, but he's got a bunch of misdemeanor files as well. I can just stand in on all the misdemeanor files.
Thank you. And Mr. Anderson, you can hear us from the jail?
Yeah.
Okay, today was the date and time scheduled for a competency hearing. The court is in receipt of a report from the State of Michigan Department of Health and Human Services Center for Forensic Psychiatry. It was dated February 5th, 2026. Counsel, did you both get a copy?
Yes, Your Honor.
Yes, Your Honor.
Okay, the report does opine that the defendant is now no longer incompetent to stand trial. He has been deemed competent. Any reason to object to the findings or the conclusion of the report?
Not from the people.
I'm not objecting, Judge. If I could just make a very quick record.
Please.
Normally, I have a big problem with the reports that come in like this, where the forensic center never actually transports the defendant to the hospital for any treatment, and they just say, take these pills, and we're gonna leave you in the jail and check on you for half an hour once every 90 days or so. And I think there's a whole slew of problems with that. With that said, I usually object to that, but in Mr. Anderson's case,
having met with him this morning, Mr. Anderson seems like a completely different person. He is absolutely oriented to time and place. We had the first rational discussion we've ever really had. He absolutely understands what's going on now. He is ready and willing to both engage in the defense of his cases and to assist his lawyer in that defense. At this time, I really don't have anything to say to challenge his competency. I just, quite honestly, it just drives me nuts when the
Yeah,
forensic center-
yeah, I would agree.
So I just wanted to make a quick record of that. It does seem that in Mr. Anderson's case, it worked.
And maybe in his case, it was just an issue of being, I don't know if he was previously on medication or should have been, maybe just wasn't compliant. I don't know. I
Right.
think as a general practice, I would agree with your concerns that can't be the way that we are restoring competency as a general course.
Agreed.
With that being said, it worked in this case, and it seems like your client is back on track and ready to proceed with helping to engage in his defense. The court will adopt the report and incorporate it into the court file. An order of competency has been entered, and this matter that you're representing him on, the felony matter, needs to be set for a new exam date. Is that correct?
That's correct.
Just an exam? Just an exam.
March 26th at 9:30.
March 26th at 9:30. For exam on that.
Understood, Judge. And I assume that the court will set other dates in the pre-trials or the
Correct, we're
misdemeanor.
gonna set those for pre-trial. The other ones are all misdemeanors.
Yeah, I believe so, Judge.
I don't think there's any ordinances. I think they're all statements.
Right, now, is there any expectation that this is something that could have a global resolution?
I suspect that's at the very least, I suspect that's possible.
Okay, because if that's possible, I can set it for, I would be inclined to set it for a pre-trial sooner and then set maybe the felony on a PCC on the pre-trial date to see if it could be resolved.
Your Honor, it looks like we were intending on having a mental health court offer.
Okay.
So we're looking into that.
Okay, so he would need to be screened, or
I'm not
that
aware.
we not even gotten that far yet?
No, we haven't gotten that far.
Okay, so I'll note mental health court offer is possible. Let me get a pre-trial date.
March 3rd or 10.
March 3rd will be the pre-trial date
Sorry, what time?
at 10.
Got it.
Any additional matters for on the record for these files?
Not from the people.
Not from defense, Judge. Thank you.
Thank you, you're all set. Mr. Anderson, you're all set.
Thank you.
Okay, on the record in the state of Michigan versus Elise Cooper, 25-02765, appearance for the record.
Anna Buckingham for the people. Aaron Robinson, Assistant Public Defender for Ms. Cooper.
Okay, Ms. Cooper is scheduled today for sentencing. And then I have a pre-sentence report for her. It was prepared on the 28th of January. Council, did you get a copy of that?
I did.
We need to make corrections, updates, or deletions.
Yes, Your Honor, just to the amount of time and the sentencing date. I believe it says that it's scheduled for the 30th, if my, yeah, there we go. So it says that it was, or she was in custody from 12/5/25 to 1/30/26. She's still currently incarcerated and is being held at the Eaton County Jail today. So I've added the days from the 30th till today on there, and I believe that total is now 74 days.
Any other corrections?
Talking to people. No, Your Honor.
She's been in custody since September.
She was in custody briefly in September and then was let out, and then the Eaton County charges came up and was put back in custody.
So she was in Eaton County at least since the 5th of December until
Currently.
currently. I'm just looking at that because of these warrants. She would have been in custody. But not in October, that's why, that's it. Okay, got it. Okay, I have two files here, City of Lansing on this one, or these two, I should say, versus Miss Cooper, 23-02595 and 25-02816. They're both in warrant status because she was supposed to appear before Judge Flores back in October. What happened?
During my first incarceration, my ribs got broke, and then I also caught COVID and pneumonia at the same time. And I have Sparrow Hospital documentation for that, not with me, of course, because I'm incarcerated in Eaton County, but I do have paperwork for hospitalization of that. That's the only reason why I missed it. Other than that, I've been making sure I be adamant about making my court appearances.
I have this matter reset for pretrial. It's a furnishing false information. You have a driving while license is suspended. That needs to be reset as well for Judge Flores.
March 3rd at 11.
Yeah, it looks like we were supposed to have a pre-trial on the driving while license that's ended on January 20th. You were in custody
I
then.
was in custody, correct. They never called me out, but then they came back supposedly to get me on the 30th, and that was rescheduled.
Then this one.
And I kited actually to see what happened. I kited ahead of time for that court date to be prepared. And nobody responded.
What is the no proof of insurance status in the system?
What's that?
No proof of insurance. They tried to set it for January 20th at 9:30, but it says PR bond, so I don't understand.
It's defaulted.
Yeah, the notes on here are not accurate. I'm gonna set aside the default. They set it for January 20th, but. All right, so she had an explanation hearing on the 20th. When did it default? Is it in October?
Yes.
Okay, got it. Set that for a show cause on the 3rd. So those have been addressed. Okay, back to the sentencing. And she's also being detained on some matters in 56, correct?
That Eaton County, I think, yeah,
Yes.
yes, that's where she's being detained.
And she'll continue to be detained even after today.
Correct.
Did you want to make allocation?
Yes, Your Honor, we would ask the court to sentence Ms. Cooper to a time served of 74 days in this case for the time that Ms. Cooper's been in. She is currently incarcerated in Eaton County. She doesn't have an out date as of yet, but she is looking at possibly doing a felony plea that would involve some sort of probation out there. There's just no specific date of when that would occur, and I wouldn't want this case to interfere with her ability for that to happen for her in this case.
Did your client want to make a statement?
I have been strengthening myself since I've been in Eaton County Jail. It's not been an easy road. I lost my husband a few years back, and he gave me the best parts of him during that time. Unfortunately, with me losing him, it has not kept me on the best roads. I went into serious depression. I have mental health issues in my family, even though I've been in denial of such, I won't claim that on me. But being in Eaton County Jail recently, I've been able to strengthen myself, allowing me to see that I have to deal with him being gone and I'm on my own. So I'm remorseful, of course, for this situation. I apologize for it happening. I was very truthful in this situation when it originally happened with the officers. I did not like the outcome of how it came about. There was a lot of excessive force, but I accept it and I'm dealing with it, and I'm good. I'm on a good note now. I want this to be over.
Yeah, you have a few things that you still got to navigate through. I'm happy to hear that at least while you're having this time in custody that you are reflecting and you're making some changes to make sure that when you are re-entering into society, that hopefully you won't continue on this path. My condolences to you on the misfortune that you had with your husband. I know grief can be a difficult journey, so I will pray that you find some peace and sanctity in that journey. You've served 74 days on this, and I give you credit for that. That'll resolve this file. And then you do have two court dates in a show cause scheduled for Judge Flores on March 3rd, okay?
Okay, so those are combined.
They're on the same date.
Thank
The two separate case numbers though. So do you have any questions about that?
No, ma'am, thank you very much.
No problem. Any additional matters for the record?
Not from the people. No, Your Honor, thank you.
Thank you. You're all set.
Thank you. Y'all have a great day.
Same to you. Give me just a moment. We're supposed to run our name is Mr. Raleigh here? No?
Probably just stepped out briefly.
Could we
How
do
long
Lucrease
is-
Evans instead?
We're running that.
Yes, that is being run as well.
How many witnesses?
One, most likely one, maybe two, just in case.
We can bring up Evans.
Just don't worry about it.
You can bring Evans up, LaFreeze Evans.
Thank you, Evans, okay.
Have a good day, Your Honor.
Thank you, ma'am. Okay, on the record in the matter of the state of Michigan versus Caprice Evans, 25-02611, appearance, please.
Good morning, Your Honor. APA Burt Buxton on behalf of the people of the state of Michigan.
And good morning, Your Honor. Robert Palmer, of the Public Defender's Office, on behalf of Priest Evans, who's seated to my right.
Okay, Mr. Evans was scheduled for a prelim today on assault with intent to do great bodily harm and an aggravated assault. And my understanding is that we're ready to proceed.
That is correct, Your Honor. The people are ready.
Thank you.
Preliminary matters.
Your Honor, at least from the defense side, I would ask for sequestration of witnesses. It's my understanding it might be just a one witness exam, but I'm asking for sequestration just in case.
And I do have officers just in case they are not here in the room. I have no issue with sequestration.
Sequestration is granted.
Thank you, Your Honor. The people would call assignment AJAC.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
Okay, you can have a seat, please, sir. Okay, so there's a microphone in front of you. That is so that the court reporter behind you can hear all of the testimony that you give here in court, but it will not make your voice louder for us. So please keep your voice loud and clear, okay? Okay, try that again, okay?
Okay.
Thank you. Also, if there's an objection from either of the attorneys, you have to stop speaking so that I can give a ruling on that objection. And then I'll tell you if you're allowed to give us that answer. All of your responses must be verbal. You can't do head nods or head shakes or uhs, because we cannot write that accurately into the record. If you forget, we'll just ask you if that's a yes or no, okay?
Okay.
State your first and last name and then spell both.
My name is Simon, Simon. Last name is AJAK.
You can proceed, counsel.
Thank you, Your Honor. Is that Mr. AJAC?
Yes.
Okay, thank you. Mr. AJAC, do you know the defendant, Pierce Evans?
Yes.
How do you know him?
I know him through 2010. We bought the property. We give the contract to somebody who was doing the roofing. Mr. Rabin ended up to be one of the roofing guys working on the roof on my property. That was the first time that I know him. Second,
You said he was working on the roof?
he was one of the roofers.
Okay.
That was back in 2010?
2010. That was the beginning of knowing him.
Okay.
2024, there was a property on Michigan Avenue, 1114. I bought that property. And the property was related to him. His aunt, the old lady, was the one who owned the property. So he.
Judge, I'm just gonna object. It feels a little bit like we're just testifying in the narrative now. Like, I mean, he can say, I know him from a construction project in 2010, but reciting a 15-year history, I don't think is necessary.
Objections granted.
Understood, Your Honor. If you can just answer my questions, we'll make sure to get everything. No problem. So you said that you had contact with him in 2024, and is that because you bought a property? How was he related to that property?
His aunt was the one who owned the property, but he passed.
You said his aunt?
Yeah, one of the relatives.
Okay.
But the property was taken away from them. And they were looking for somebody to buy the property.
And so you were the one that ultimately bought that property?
Yes, and it was through other agents.
Is Mr. Evans here in the courtroom right now?
Yes.
Could you please identify him by a piece of clothing that he's wearing?
He is on my left hand on the red chest.
Thank you. Your Honor, may the record reflect that the witness has identified the defendant.
Any objection?
No objection for exam purposes, Judge.
Identification order.
Thank you, Your Honor. Mr. Ajak, did you have an incident with Mr. Evans on August 25th of last year?
Yes.
And where did that incident occur?
It occurred in front of my property at about 5:25 to 5:30 in the morning.
So that's, I just want to make it clear, is that at the 1114 West Ottawa Street?
Or right there in my property.
Excuse me?
Yes,
And that's in the city of Lansing,
yes,
Ingham County, state of Michigan?
yes.
Could you please explain what started this incident that early in the morning? Or I guess, what were you doing before this all happened?
I woke in the morning. I started my work at 6 in the morning. So I got out. I want to go and start my car going to work. So the battery of my truck died. So when I start the car going to work. So what I did, I have an old car in my car garage. I went and grabbed the car in order to jump the car.
Okay, so you were jump starting your car?
Correct.
Okay. Did you see Mr. Evans at some point while you were trying to start your car?
Yes, I saw him with another guy coming toward me. They live across the street at the shed.
I'm sorry, I don't have an objection. I just want to make sure I understood what they said. They say that there was two individuals that were coming out?
Yes.
Yeah, he said the defendant and another guy was coming out,
Yes.
and then I don't understand what he said after.
And I believe you said coming from the shed.
Yes.
Okay.
So could you explain this shed then to the court?
Okay. There is a property, 1115. That property is owned by somebody by Steve. The shed is behind that, and that is where Mr. Evans lives.
Okay.
And he was coming from that shed. I'm very sure he does take the trash out for that property. So he was coming out with another guy.
To take out the trash from the property?
Yeah, he was coming toward me,
Okay.
because I'm on the other side of the street and he is on the other side of the street.
Did he end up making contact with you on that day?
Yes, he attacked me with his body.
So when you say attacked, could you explain to the court exactly what he did?
All right, so when I was jumping, he began, to tell me some of the things that I failed to understand. Was telling me it's not a jump start. He began to curse me out, and I did not respond to anything about that. He came closer and I said, man, I gotta go to work. Immediately, that is when he began, to slam, beat me on the face against my own car. Then he threw me out down. I managed to overcome him, his body up him, and they put me down. He was choking me
Okay.
that particular day, and his body was recording.
Okay. So I want to take it back for a second. You said that he was beating you on the face. How was he doing that?
All right. He, like where you are standing, did this. All right. I was standing. He did this, and this is my car. So I was against the car. All right. And he punched me in the face, put me against the car, overpower me. Then I managed, he was the one laying down before me. Then his body came, both of them pulled me down. He jumped on my chest. He was the one choking me, and the other guy was doing the recording.
Okay, so you said that he was choking you.
Correct.
How was he choking you?
So I was laying on my bed. He was sitting on my chest, put his arm on my neck, and one of my arms, he was trying to pin both arms, squeeze them, but he would not manage. One of my arms was still out. So, and then when they were doing that action, it was a minute I yelled, but there was no voice coming out. My nose, my mouth, everything was coming out. His body, and I was blank, one blank, could not know anything. His body said he is dead. He's dead. That is what his body said. All right. And somehow there was a car coming, or maybe there was a sound. Then he got out. Then they left. Was still down. Minute. After that, could be a minute. Got up. Came, sit in my property. Called the cop. Cop came. Both of them, two guys came. I was taken to hospital, but I told the story, but I could not comment.
Again, Judge, I'm
This is a narrative.
Yeah.
Understood. Sorry, we gotta ask questions. You can't give too long of an answer. So I want to go back then. You said that he put his hand on your throat.
Right.
Did he apply pressure?
Yeah, he applied.
And you said that you were unable to speak.
Correct.
Did you have trouble? Did he impede your ability to breathe?
Yes, he knocked my ability, but I was trying to yell so that somebody can hear me for help, and nobody.
So it was difficult for you to breathe while he was squeezing?
Correct, and even to raise any voice.
And you had said that you had ultimately called the police.
Yes, yes.
Was the defendant still present after you had called the
No,
police?
they left. They left me on the ground.
Did you see Mr. Evans later that day?
On that day, yes, I did. I did see him at about 3 after I came out from hospital.
So you ended up going to the hospital as a
I
result of all
was
of
taken
this?
to hospital. Emergency came, ambulance came. I was bleeding. Both on my knees.
I want to go back real quick to when he was grabbing your throat. How long did he impact your ability to breathe, if you can remember?
It could have been, I could not say it about the minute, but the action took a minute, it took time.
So it was for an extended period of time?
Correct.
When you saw the defendant later that day, did you call the police again?
Yes, I called the police.
And did the police arrive?
The police did not arrive on time, but eventually they came at a later date.
Understood. What kind of injuries did you have as a result of what happened?
My knees were skin out, my neck, my chest, and so much everything on my mouth, my neck. And the police actually took some pictures at that particular time.
Perfect, nothing additional, thank you.
Cross-examination.
Thank you, Judge. Mr. Ajak, it's Ajak, is that right? Okay. I just have some simple questions for you. You indicated that you knew Mr. Evans prior to this day, is that right?
Yeah.
All right, and you said you knew him about 15 years?
Yes.
Okay. And had the two of you previously had any trouble with each other?
Objection, Your Honor, relevance.
Do you want to respond?
I do, Judge. I think it goes directly to his motive and state of mind with regards to his testimony today. I think if there's a history of violence or animosity between the two, I think that's directly relevant.
I'll allow it. Objections overruled.
Had the two of you ever exchanged difficult words or been in fights before?
We never fight before. But there was one incident that I'm aware of. And it was right after I bought the property.
Okay, well, look, let me just ask this. I'm not asking you to go into detail about all of it, right? I'm just asking you. So is it fair to say that prior to this incident, you guys did not like each other?
On my end, no. On my end.
Okay. No, you didn't like him?
No, on my end, I don't have a problem with him. That's a person.
Okay. How often did you lived across the street? Is that right?
Correct.
How often did you see him? Did you see him every day?
Well, I walk every time, and when I see him, I can see him cutting the grass across the street.
Okay. But you didn't, did you guys?
No, we don't have that.
Okay.
We don't have the conversation of talking to each other every single day. No.
Okay. So on this particular day, it's somewhere around, I know you don't know an exact time, but it's somewhere around 5:30 in the morning. Is that right?
Yes, because I'm going to work. Yep.
Okay. And so you saw him coming out of the shed? Is that what your testimony was?
Yes, because yes, the direct driveway, you can see the direct driveway whereby that is the door right there. And if I see you coming from that door, I can see you.
Okay. And you indicated he was with another person at that time.
Correct.
Do you know who the other person is?
I don't.
Had you ever seen him before? The other person, that is?
Based on what I was told.
Well, all right, let me stop you. Okay. I don't want you to tell me anything about what you were told from anybody else. I'm just asking you personally, had you ever seen this other person before? Yes, I saw him, but do I recognize him? I may not know. Okay. You don't know the other person's name, is that right? I don't know his name. All right. You saw the other person, I think you said you saw the other person recording something on their phone. Yes, both of them were he was doing the action. The other guy was standing. Was just standing there? Just was standing. Did the other guy ever participate in, like, did he ever strike you or knock you down, kick you, punch you, push you, anything like that? He helped, yeah. The other guy helped? Yeah, he did help him. Okay. And you said that you were originally behind, or not behind, but you were in front of the car doing a jump start on the car, is that right? Yes, I had two cars. Right? Two cars. Okay. One I'm jumping, one I'm using the car. Right, sure. Did you actually see them walking the entire way towards you, or were you behind the car and so you couldn't see them until they were right there? Yes, I see him. The other guy was in the distance, but he was the one coming. He is in my client was the one coming. Yeah, he was the one coming. And he walked up to you, and there was a period of conversation at first? Yeah, he was talking to me and said it is not a butt train. He was kind of like, it is not a butt train, it's a jump start, and it was cussing out, and I did not say anything. Okay, so at first you thought, was your personal impression that he was there to be helpful or what? I did not even thought about whether he is gonna harm me, because I never have any problem with him before. So I have no intention that he is gonna do harm to me or trying to kill me. Okay, just to be clear, I'm not asking you what was said, okay? But were you both talking back and forth to each other? Was there a back and forth, or were you staying silent while he was talking to you? He was talking to me, and I was not talking back to him, but I was concentrating because I gotta go to work and I gotta jump my car. Okay. And your testimony is that just as he's talking to you, he just out of the blue punched you.
I ignored him.
You ignored him, and so he just punched you.
Correct.
All right. And did he punch you in the side of your head or directly from the front? What?
Oh, on the side.
On the side of your head.
Right.
Your right side or your left side?
On my right.
On your right hand side.
Right.
All right. And he was on the right hand side of you at that time?
No, he was not on my right hand side.
Okay.
So if I can demonstrate it, this is the car I'm jumping on my left. This is the car that I'm using.
Okay. So you're in between the two cars.
And I'm in between the two cars, especially the car that I'm using.
Sure.
And he was coming toward that direction.
So
he was swinging.
Yeah, but was he, when you're saying you got punched,
right?
Was he behind you or on the side of you?
He was on side of me.
On the side of you?
On side of me.
On your right side?
On my right side.
And did you see whether he punched you with his left hand or right hand? If you don't know, that's okay too.
So I think it was a right hand.
Okay.
Because he's swinging.
Okay.
And that is when I realized, okay, now something is.
Where was the other guy at this point?
The other guy was just still standing. He did not do any action. The action when he came in is when he threw me down and I managed him. He was the one going down first.
I'm sorry, you said when he threw you down and you what him?
He put me against the car. It's two of us now. All right. Put me against the car. There is no other way. So we are wrestling right now. Okay. So instead of me going down, I managed. He was the one going down. His body came down. He helped him. They flip me down. And then he jumped on my chest.
Okay.
And then the other guy stand up and record him.
All right. Let me make sure I understand what you're saying. All right. I don't want to put words in your mouth. I just want to clarify. All right. So you're saying that the two of you and my client started essentially wrestling. You're up against the car and you started to throw him to the ground.
Correct.
And then, correct, right? Is that what you said?
Yes.
All right. And then you were throwing him to the ground. And then once that happened, once you got on the ground, the other guy, not my client, but this other third person that was there, essentially flipped you over so that you were on the bottom?
Yes.
Okay.
Yes, yes.
And then once you were on the bottom, are you saying that my client was on top of you?
Correct.
And it's that point where you're saying your testimony is that he choked you.
Yes.
And he choked you with his hand?
With his hand.
Where were your arms at this point?
One arm he managed to lock it down. And one arm he wanted to lock it down, but he did not manage.
Okay.
So my right arm, he did not manage.
Okay.
And I'm very sure that is what saved me.
Okay. And he choked you with his left or right hand?
He's trying to apply both hands.
He was trying to apply both hands?
Correct.
How was he applying both hands if he's locking your right hand down?
So he's trying to bring my hand down here and he's locking this one down and lock it down. Suddenly, and when he's trying to bring this one hand here, he's trying to grab me in a minute, and then I went back and pulled his arm out. So it's one arm versus two arms against him. So he got two arms and it's one arm.
And you said that he put his hand on your throat and squeezed, right?
Right.
And do you remember giving a statement to the police?
Yes.
And you told the police that he strangled you for 10 minutes and you lost consciousness. Remember that?
Correct. You
still agree that you were being strangled for 10 full minutes?
Correct.
I have no further
Any redirect?
No, Your Honor.
Okay, thank you. You may be excused, sir. Mr. Ezra? Yeah. Any other witnesses?
No, Your Honor, the people were blessed.
Any defense witnesses?
No, Your Honor, thank you.
Argument?
Yes, Your Honor. The defendant in this case has been charged with 1 count of assault with intent to do great bodily harm less than murder or by strangulation, and count 2 of aggravated assault. Obviously, the aggravated assault is a misdemeanor, so I would ask that that follow the felony, and as we are only here for the felony charges at the preliminary examination. The elements for assault by strangulation can be found in the Michigan Criminal Jury Instruction 17.35. And there were 3 elements for that charge. The first is that the defendant committed a battery on Simon Ajak, a battery being a forceful, violent, or offensive touching of another person or something closely connected to that person. You heard from Mr. Ajak that on August 25 of 2025, at his property that was on West Ottawa Street in the city of Lansing, Ingham County, state of Michigan, while he was trying to jumpstart his car, the defendant and an unknown second person showed up, punched him, took him to the ground, got on top of his chest, and then started strangling him with one hand, as he referred to as choking. This is clearly a forceful, violent, and offensive touching. Number 2, the touching must have been intended by the defendant. That is not accidental, and it must have been against Mr. Ajak's will. It does not matter whether the touching caused an injury. As you heard from Mr. Ajak was just trying to jumpstart his car. He wasn't trying to have any trouble and was ignoring the defendant while he was making all of his statements. However, what ended up happening is the defendant got upset. The defendant punched Mr. Ajak and once again brought him to the ground, got on his chest, tried to lock his hands down, and ultimately ended up choking him and putting his hand on his throat and applying pressure. It's clear, Your Honor, that this was intended by the defendant, and it was against Mr. Ajak's will. Element 3 is that the battery is committed by strangulation or suffocation. Strangulation or suffocation means intentional impeding normal circulation of the blood or breathing by applying pressure to the throat or neck or by blocking the nose and mouth. And you heard from Mr. Ajak that while the defendant was choking him, he described that choking as putting his hand on his neck and applying pressure, so much so that he was unable to speak. He was having difficulty breathing, Your Honor. It shows that there was a clear impeding of the defendant's, of Mr. Ajak's breathing by the defendant. So we have met all the elements and we ask that you bind over. Thank you.
Thank you, Your Honor. First of all, I'll just say I recognize that probable cause is a low standard. I recognize that I recognize the elements of the offense. I do think there are some significant holes in the story. For example, I find it, quite frankly, highly incredible that he was strangled, actually strangled for 10 minutes. I've personally handled homicides in which the person was strangled for way less. The person died from strangulation way less than 10 minutes. That seems highly unlikely to me that assault occurred, that a strangulation occurred, that he lost consciousness and was strangled for 10 full minutes. But nonetheless, I recognize it's a probable cause standard. I would submit to the court that this is an aggravated assault at best. I would ask that the court dismiss for lack of probable cause with regards to the content.
Okay, for your benefit, Mr. Evans, this was a preliminary examination. So the burden is on the prosecutor to show probable cause that the felony that you're being charged with actually was committed, just to a probable cause standard. They also have to show probable cause that it was you who allegedly committed the felony. They don't have to prove each element beyond a reasonable doubt. And any issues that relates to a question of fact that comes out of the evidence, that's something that has to be resolved over at a trial. And so we have testimony today from one witness, that being a Simon Ajak. He testified that on or about August 25th, 2025 at the area at or near 1114 West Ottawa in Lansing, Michigan, making venue in this court appropriate, that he was outside jumping his vehicle when he saw the person that he previously knew or knows to be the defendant in this matter, Latrice Evans, coming from the shed at 115, which he says is owned by someone else, and that the defendant was with someone else, and that the defendant approached the victim, slammed him by the face or beat his face into the vehicle, is what it sounds like he did. That there was some kind of tussle that ensued after that, that resulted in them being on the ground. It sounds like through cross-examination, the victim was able to push or pull the defendant onto the ground, but then the friend that was there did help get the the defendant on top of the victim, and the victim testified that he was strangled or choked is the word they used for approximately 10 minutes. The prosecution has already gone over the elements of assault by strangulation. And again, the defendant allegedly would have committed a battery upon Mr. Simon Ajak, battery being a forceful, violent, or offensive touching of another or something closely connected to another. I think the testimony is clear to a probable cause standard that there was some violent, forceful, or offensive touching that took place at the hands of the defendant. Second, that the touching must have been intended by the defendant, and that is not accidental, and it must have been against Mr. Ajak's will. It doesn't matter if the touching caused an injury. I think based on the testimony of Mr. Ajak, that we have met the burden on that element. However, the battery was committed by strangulation or suffocation. Strangulation or suffocation means intentionally impeding normal circulation of blood flow or breathing by applying pressure or on the throat or neck by blocking the nose or mouth. The incident that was described by the alleged victim again was that the defendant had him pinned down and at some point had his at least one hand around the victim's neck. The victim did indicate that he believed he had been choked for about 10 minutes. And defense is arguing, obviously, that it's hard to believe that someone can be choked, and what we know is actually strangulation for 10 minutes. But it could be that maybe the victim, maybe it felt like 10 minutes. He testified it took the police a long time or to get there. Maybe that's what it felt like. Maybe that's his perception. Maybe he's completely wrong. I don't find, although I find it hard to believe too, I don't know that that discredits the other portions of his testimony, which is that he was minding his business, working on a vehicle when he was approached and attacked. I also think there are some holes there, because not to say it's not likely that someone can attack you unprovoked, but for someone who you've obviously known for, it sounds like a period of at least 10 years, that they've never had this type of interaction, and then all of a sudden you're outside, he comes outside with someone else and attacks you, something's missing, I would believe as well. What that something is, I don't know, or whether or not that something was something that would make me feel like what the story that was told to me today lacked credibility. I don't believe that. I don't believe that. I don't know that there's a lot that could have happened that could have warranted or dismissed an assault by strangulation. And the other concern that the court has is, although maybe it was 10 minutes, it could have been a long period of time where pressure was applied, but not enough pressure that would have caused him to lose life and or consciousness for 10 minutes. I think he did testify that there was a portion of the strangulation where he was attempting to scream for help, and that because of the pressure on his throat, he was unable to really do that. So maybe it wasn't as much pressure for the 10 minutes as maybe some of the other portions. That's something that could be fleshed out further if this matter goes to trial. I think there is sufficient probable cause, though, based on the testimony, to bind over count 1, and count 2 will accompany count 1 to the circuit court. Bind over date being February 25th. Will be the date the circuit court receives the file from the district court. not a court date for you, okay, Mr. Evans? Your next court date will be a pretrial. Your attorney will be made aware of that date. Do you have any questions today?
As Ms. Palmer had explained to me, well, first of all, I would like to get the forensics report. Secondly, Mr. Palmer had advised that he was not going to be representing my case any longer, and that different counsel would be appointed.
I don't know anything about you getting a new attorney or a new appointment. The public defender's office appointed Mr. Palmer. And if they decide they're gonna remove Mr. Palmer and put someone else, that's their business. The court doesn't have any involvement in that. He's the one who's been assigned to handle your case. Now, if you're requesting for a new attorney, and you want to hire your own attorney, then you need to get your money together and or find you another attorney. But you don't get to decide which public defender represents you. Do you understand that?
Yeah, of course I do. I'm just saying this is what he just.
Yeah.
Okay, I'm not sure that if that's the case, again, the court would have no knowledge and or input on which public defender gets assigned to your case. And so at this time, Mr. Palmer is the one who's been assigned. If they're going to switch that, that's up to the public defender's office. The court doesn't have any involvement in that.
Just to be clear, Judge, I did advise him that it is not anything that has to do with Mr. Evans. It is the fact that I have accepted a new position outside of the public defender's office. And so I'm leaving. There was at one time a discussion that Mr. Evans may be assigned new counsel prior to today's date so that that individual could be present to conduct the preliminary examination.
Okay.
For reasons I don't understand, that didn't happen. But I did advise Mr. Evans that I will not be his counsel after.
Got it. So you're leaving the public defender's office.
I am,
Got
yes,
it. Okay, well, congratulations to you.
Thank you.
And so for those reasons, obviously, you would have to get a new attorney because he won't be there to represent you. Again, the court has no input of who that attorney is going to be. It'll be someone assigned by the chief public defender, okay?
Can I address the court?
You can.
I would like to, first of all, I would like a copy of the forensics report.
Did your attorney
I can give it.
got a copy of the forensic report and can get you a copy?
Yep,
Okay,
I've got a
well,
note
I
about
would
that.
also like to state that on the date of the 10th of December, Mr. Palmer had called me at approximately 3:30 on that day and explained to me that I would be detained because I missed the forensics examination, which I had no knowledge of. It gave me no information of that date. I was in constant company with pre-trial and was on television, so there was no way to not have been recognized. That date had been recognized for forensics. So with that being stated, ma'am, the other day, went to court on that the 30th or something. I had just woke up, had no pre-knowledge of that I was even going to court. Like 10 minutes, they're like, Evans, you're going to court. I'm like, what? I had no knowledge of even it was a court date scheduled for me. So, with that, ma'am, I was a little groggy, uncomprehensive, as you might say, and this is how we ended up getting me the 90 days. With that being said, ma'am, I would like to know if you would try to at least give me some credit for that, the days that I've already served on that contempt charge and reinstate my bond.
You got found with contempt because of your disruptive behavior, not because you were groggy.
Understandable, man, but I'm just letting you know that my due process of rights has to be a certain amount of time before you to be acknowledged that you go to court. I had no knowledge.
Not for direct contempt. You were disrespectful and caused a complete disruption to me in court. Excuse me?
There was no precedent.
So now you get to determine contempt in my court.
No, ma'am.
Okay. The contempt will stand. It's 93 days, Ingham County Jail.
Well, what about what he has done, like as far as like me not having understanding?
Well, who has done?
What he did, as far as
your attorney,
Mr. Palmer. I stated that on the 10th. He called me and said that I missed a court date on the first. He didn't do anything. So you're trying to blame it on him that you missed the competency? Well, I didn't have any knowledge of my competency hearing.
Okay, so there was more than two things going on here. There was also a court date scheduled here for December 11th. that you didn't appear?
No, I did. I was here. Yeah, when I got here, you weren't here, and Mr. Palmer was not here.
That, just to be
This guy
clear,
right
Mis-
here, this guy was here, and there was a
He-
black lady over there that was there.
Judge, just to be clear, on that date, he did appear eventually. By my notes, he appeared a couple of hours afterwards. I think he had transportation issues.
And he was
Well, I
remanded
was
for
stuck-
failure to appear
Yeah,
to
I
the,
was
co-
stuck,
to
I
the.
was stuck in the snow. But what I'm saying, what I'm asking you is that, what is the deal with him not giving me, I didn't even have acknowledged that I had a competency hearing date, and I was remanded on the next day that I went to court. You see what I'm saying? So, like, I shouldn't even been in jail. I should just now be going to jail. But I'm like, there's like 60 or 70 days of my life that, they're unaccounted for, and he's responsible.
He's responsible for 60
Ma'am,
days of
he
your
did
life.
not give me, he did not.
Man, sir,
I'm trying to
sir,
say
see,
is-
this is
what
how
I'm
you,
trying to
this is
say
how
is
you
that
got here in the first place.
Ma'am, he
Why-
did
This
not
this is how
give
we
me-
got here in the first place. Did you give me an opportunity to finish my sentence before you cut me off to yell over me?
Well, that's what I was.
No, I'm asking you a question. What was my question I was about to ask you?
You didn't finish it.
Why? Because you cut me off.
Well, man, you cut me off too.
No, I didn't. And if I did, I get to cut you off at a portion that I need clarity for. I am the one running the court, not you.
I'm saying.
So when I cut you off, it's because at this very point, I need some clarification. So you have to stop to allow me to get clarification right there. Do you understand that? So you're saying that you did not know that you were supposed to have a competency evaluation, and that Mr. Palmer was responsible for letting you know that?
Yes, he was.
It's fine.
Judge, I think that's actually true. I want to be, I'm an officer of the court, and I think I absolutely have an obligation to be
I agree.
100% truthful with the court. So I'm not going to try to hide anything here. I was not aware, and I've been looking into this as to why, but I did not see the competency or the order for his appointment until after the fact. I have some suspicions on why that happened. I have some suspicions about why that happened, and I'm just going to say that regardless of why I think it happened, it is ultimately my responsibility. I don't want to pass the buck. I don't want to try to make the court think I'm passing the buck to anyone else. I will fall on the sword and take responsibility for that. What I will say is that, and so I think to some extent, Mr. Evans is correct in what he's saying. And I don't want him
That
to
he
be.
was remanded, but it was not his error. It was he did not have knowledge.
I think that's true, Judge. And one of the things I just want to remind, to at least to my recollection of what happened. I started to address this very issue at our last court hearing. And then Mr. Evans was also talking, I'll put it that way, while I was trying to make the record, and the court found him in contempt before I could really get into that issue.
I didn't find him in contempt for talking.
Or for speaking over you and interrupting the court.
He berated the court.
Right. I'm not trying to.
And he thinks it's funny.
I understand, Judge.
He said that he thinks it's funny. Listen, if there's.
This is fraud of the court, so.
Excuse me?
This is fraud of the court for what?
I don't know what you're saying.
You don't know what fraud of the court
I didn't hear what you said. I don't know what you're saying.
Fraud of the court is?
Fraud. I didn't know what you were saying. I wanted you to repeat it. What's fraud on the court?
Fraud of the court.
It's not fraud of the court. The court has there was the responsibility of your attorney to notify you. That's what this says, that you were scheduled for an appointment with forensics, which the court ordered you to undergo some forensics. I don't know what the breakdown between you or your attorney was, because that's nothing to do with me. That's to do with you and your attorney. If there was a breakdown in the communication where there was your attorney didn't get the notice, or your attorney did get the notice and didn't get it to you, that's between you all. Before he could address that, which was last week, or a week ago, a little bit over that. Before he could address that, you became disruptive and we could not carry on a hearing. So I had to remand you because I couldn't get you to be quiet over there.
That's not true, man.
It's not, this is not up for debate. This is recorded in open court.
Yeah,
It was not, it's not, you can feel free to FOIA and or subpoena a copy of the record if you would like to. The court made its ruling, then the court stands by the ruling. Regardless of whether or not there was an error made by your attorney, does not give you grounds to come into the courtroom and be disruptive.
We violated my rights.
And then no, I didn't violate your rights. You came in here today and tried to say the reason why you were disruptive is because you were groggy. Now it's because your rights were violated.
Ma'am, you misinterpreted.
You can be
what I'm saying.
excused. You can be excused. I can carry on the remainder of the hearing without you. You're all set. You're all set. You're all set.
I know I am, saying, you want some words here.
Yep, you can get another 93 days. All set.
Yeah, whatever.
Yeah, another 93 days.
Whatever, kids. 93 days.
He was not found in contempt because he was talking. It's because he's disgustingly disrespectful.
Your Honor, I'd like to go a step further. I was there for that hearing.
Thank you.
Your Honor was attempting to figure things out with the forensic review process with Mr. Palmer. And you turned at one point and said, I'm trying to figure this out for you, something along those lines. And that's when you were yelled at by the defendant over Zoom. So I'd just like to put that on the record as well, that you and Mr. Palmer were trying to resolve the issue when you were interrupted.
No, well, it's consistent with the behavior that we've seen of Mr. Evans throughout this matter. And so that's neither here nor there. It's unfortunate that he was not the person who was at fault, it sounds like, for missing the forensic, but that does not give him grounds to come in and disrespect this court. And he will not get credit because of your error for coming in here, A, calling me out of my name, B, disrupting the process. So that's that. And he's getting an additional 93 days for contempt of court today that will be served consecutive to the one he's serving now. Any additional matters for the record?
Not from the people, Your Honor. Thank you.
They are, thank you.
Thank you. On the record in the matter of the state of Michigan versus George Arhem, 26-00035, appearance, please.
Good morning, Your Honor. APA Burt Buxton on behalf of the people of the state of Michigan.
Jacob Marley on behalf of Mr. Arham, who is present to my right.
Thank you. Mr. Arhem was scheduled today for a prelim on a weapons carrying concealed. Is that accurate?
That is correct, Your Honor, and the people are ready to proceed.
This defense also is prepared to proceed.
Okay, any preliminary matters before we call witnesses?
I would request sequestration of witnesses. That's all.
Understood, Your Honor.
Sequestration is granted. You can call your witnesses.
Thank you, Your Honor. The people call Officer Jake Ellis to stand.
Do you solemnly swear or affirm that you'll tell the truth and the whole truth on the penalty of perjury?
Yes, Your Honor.
Be seated. State your first and last and spell, name and spell both.
Jake Ellis, JAKEELLIS.
Thank you. Proceed.
Thank you, Your Honor. Officer Ellis, how are you employed?
With the Lansing Police Department,
How long have you been employed with the Lansing Police Department?
just under 7 years.
Were you working on October 23rd, 2025?
I was, yes.
In what capacity?
As a member of the Violent Crime Initiative, BCI.
What were you doing on that day in particular?
We were just going through monitoring social media, which is part of our regular duty, BCI, to investigate.
Did you go through the social media of George Arheem?
I did, yes.
And what made you do this?
I was just going through the different real stories on Instagram and Facebook, and from prior investigations and from when I had full experience, was familiar with Mr. Arheem and saw that he had posted a video with a firearm.
So you said you were familiar with his social media?
Correct.
What social media were you on in particular at first?
The initial one was Instagram, and then after I saw the Instagram post, I went to Facebook and saw the same video.
How did you know that this Instagram account was Mr. Arheem's account?
Except from prior experience on the road, continuing to come up in investigations, and then from knowledge from prior BCI members, also on both accounts, there's multiple photographs of him, and I was going to compare those photographs to his Secretary of State photograph, and for thoughts of the same individual.
I am going to pull up on the TV what has been marked as People's Proposed Exhibit 1.
I can't hear you. Host.
It says host isn't allowing sharing. Oh. I have just pulled up on screen what is marked as People's Exhibit 1. Are you familiar with this video based off of the screenshot?
Yes.
And what is this video?
This is the initial video I saw of something that at the time believed to be, sorry, you expect the mask, but I was on that social media account prior to flashing fire.
And I see a time on that video. Do you know what that time is in reference to?
Yeah, so the top one, that's the red, that would, when I viewed it at, 3:43 p.m. And it shows the timestamp on the story that had been posted approximately 20, it's the number, but approximately 20 to 30 minutes prior.
Okay. And does this appear to be a fair and accurate copy of the video that you saw on Instagram on that day?
Correct.
Your Honor, at this point in time, the people wish to admit People's Proposed Exhibit 1 to evidence.
Any objections?
No objection.
Thank you, Your Honor. I'm going to be playing the video now.
Is there sound at all?
There is no sound,
Oh, okay.
or I believe if there is, it's not relevant. And I'm going to bring it to around 11 seconds into the video. Did you see something pop out of the jacket right there?
Yes, that was a firearm.
The video also says Citgo King, Lansing, Michigan. Did you do something with that information?
I did, yes. So I know from working Lansing PD that there's two Citgos in the area of the South End. One being off of South and South King at Catamount, and one being at West Mount. I know that Sarheem lived at Morris River, and the closest Citgo would be just only a handful of blocks away. So that's an idea that that was the story with that.
And would that be the Citgo at 500 West Mount Hope Avenue?
Correct.
Did you do any additional investigation in regards to confirming this Citgo gas station?
I did. I went inside the store approximately an hour or so after I first saw the video. I recorded the screen, the ceiling of the Citgo. It was very distinct seeing how the lights. So I was able to believe at that point that was in fact the store that video initially.
And did you go to a additional social media of the defendant to confirm this video?
After I saw it on Instagram with Facebook, Facebook showed the exact same video. I know that Facebook and Instagram are often linked accounts. They share the same, major platform. So if one gets shared, you can have the option to automatically share it together.
You had said that you had dealt with the defendant in prior investigations. Do you know if he had current criminal charges at this time?
Well, confirming in lien, and prior knowledge investigations, I knew that he had been arrested by BCI prior to me being in the unit with a firearm and had an active case for going on. Don't remember if it was in circuit court or as long as court at that time.
Had an active case for what?
Attempted murder.
Were you aware of any tracking done on the defendant at this time?
Yes, I knew that for the bond conditions that I located in lien that he was to be monitored on his GPS.
Did you receive GPS location in regards to his location at that time?
I did, yes.
And what did that information show you?
The tether coordinates showed him in the area around his house at 615 Morris River Drive. He leaves, goes southbound, and then ends up in the 1800 block of Bradley, which is less than a block away from where the Citgo gas station is at Northwest Mount Hope. The tether showed that he was in the area by that Citgo gas station. The same time this video would have been filmed with that filter at 3:09 p.m. He then leaves and goes back to his residence.
Thank you. Based on all this information, did you do anything additional?
Yeah, so myself and other members of BCI then set up surveillance on 615 Morris River. Prior to being able to conduct a traffic stop or anything like that, we believed it was the defendant and another male got in the vehicle. Members of BCI fought into the Amazon warehouse and Delta Township. To that point in time, we canceled the surveillance. And I contacted the tether company again just to confirm if that was Mr. Arthur or not that had gone to work, and they advised that he did not payment if they had stopped monitoring his tether at 5 p.m.
Did you receive any, or did you find anything else in your investigation in regards to the defendant and firearms?
Yeah, so the next day, the 24th, I was monitoring social media again, and I located this one was a photograph on that video that indicated that he was in possession of a firearm on the same count that I'd seen prior. There's a black 6-hour pistol with rubber bands on the grip, showing the magazine and a bag of marijuana. I can see what appear to be a vehicle floorboard, so let me believe that that had been taken inside the motor vehicle.
Based off of this information, did you end up getting a search warrant for the defendant's home?
Yes, I ultimately got a search warrant on October 30th.
And were you involved in the search of the defendant's home?
I was, yes.
Was a deputy Andrew Kerrigan also involved in that?
He was, yes.
And what did you yourself find during the search of the home?
One thing I noted was the very distinct green hooded sweatshirt. It was a University of Oregon Ducks hoodie that was in the bedroom. We located some mail and some prescription bottles with the defendant's name on them, which authenticate that that bedroom that we were primarily searching focus was the defendant's bedroom.
So the green sweatshirt was found inside what you believe to be the defendant's room based off the medication?
Correct.
Nothing additional for this witness. Thank you, Your Honor.
Cross-examination.
Officer Ellis. So you stated that you were monitoring Mr. Arham's social media, is that right?
It is among others, yes.
And is this, I guess, is this a standard practice that you do in certain circumstances?
It is for our team. Oftentimes offenders will post firearms or things in commissions of crime on social media. So to further investigate violent crimes, violent offenders, we like to monitor social media. It's a big investigation.
How do you know that a social media account belongs to a certain individual?
Well, depending on prior knowledge from other team members, we have ways to, so we'll put birthdays, like on Facebook, you have Joshua put a birthday in. Sometimes people put the month or date, maybe not the year. And URLs, there's oftentimes names of the actual URL. So we can then use that to dig in through like the TLO system to search partial names, partial birth dates, go into lead and fun.
In this particular case, how did you know that this Instagram account belonged to George Army?
Well, there was several pictures of Mr. Army on it. And I know it's relatively common for most people to have pictures of themselves on their social media accounts.
Did it have any part of his name or birthday in the that was visible to you?
On the Instagram itself.
So we watched this video that was posted to that account, correct?
Correct.
The Instagram account?
Yes.
And you said it was also posted to your Facebook account?
Correct.
I guess my question is, how do you determine when that video was posted?
So based on the filtered timestamp at 3:09 and at the video, I saw the video approximately 3:45. And it's the timestamp where the reel had shown that it had been posted about 20 to 30 minutes prior to the video initially been filmed and posted about 30 minutes prior to doing it, which had been approximately 3:09.
Is it possible to post a video sometime after it was actually recorded?
It is.
Is there anything to indicate that that is not happening in this case? This was not recorded at some earlier date or time?
Nothing's GPS tether really helped.
So getting to the GPS tether, you said it showed, I think you said Mr. Arham within a block of the gas station.
Less than a block.
So what, I guess, How long is a block? Or what do you mean?
So, I mean, I don't have, it should say on the actual return from JSG monitoring the footage. So generally the GPS tethers, they get the distances and locations from satellite. It's not always a pinpoint to the centimeter. It's usually a foot type radius. And so less than a block for me is the city block over there from between Bradley and the gas station. So 50 feet maybe.
So I guess I'm curious if it's accurate to like a foot radius. Why are we only able to say he was within 50 feet of a certain location?
And that's an approximate. The tether did stop that location at the same time that the video was timestamped that filter and then left after.
In the video we saw, I think it's fair to say you can see an item being pulled out of a jacket and put back in.
Correct.
Are you able to identify a model of firearm from that video?
Based on my experience handling firearms, that appeared to me to be a 6-hour pistol. Obviously, I couldn't see any of the model or make stamps on it, but just the design of the firearm itself appeared to be a 6-hour.
Is there anything in that video that by itself would convince you that it's a genuine firearm and not some sort of replica or toy?
And that video itself.
So is what led you to assume that it was a genuine firearm?
Well, again, my experience, most people don't conceal fake firearms on their person with ski mask and seal. That usually indicates some sort of try to hide identification from community life.
Do you have reason to suspect that this was in connection with some other crime or that the gun was used in a crime?
No, at that point, it was strictly carrying a concealed weapon and bond violation.
You ever personally observed Mr. Arhin possessing that weapon or any weapon with your own right?
Nothing beyond social media.
You mentioned that you got a warrant to search the home, correct?
Correct.
So how did you, I guess what led you to believe that this was Mr. Arhin's?
Based on prior history, I said in the past, BCI had stopped and started leaving that residence, the family home, the vehicle, Subaru Impreza that was registered starting, then parked in the alleyway next to the garage associated with that residence. So that indicated to me that that was this residence, and GSG monitoring confirmed with me that in their system, that's the tethering location that 615 West River was that address.
Is that the only address registered in your in Lean or in your systems?
There's that one, and then there's address up on Turner Street. But based on the tether locations also showing the frequenting Morris River, I believe that as where he had been residing at.
So you, among other officers, conducted a search of that home. So you found some weapons, is that what you said?
Well, we found, among weapons, yes, we found some clothing and some identifying paperwork with Mr. Arhin's name on it.
Never you believe that a certain room was Mr. Arhin's room in particular, and not someone else's room?
Correct, yes.
You know how many people were living in that home at the time?
There's, I think maybe about 4 or 5, I believe. Can't say exactly.
Just to be clear, just so we're not missing anything, the only time you saw Mr. Arhin was something that might be a concealed weapon was in that Instagram/Facebook feed, correct?
That one, and then the post saw the day prior, or the day after, on the 24th. Just the two occurrences.
So what was that one? What do you see in that?
That was the one where the vehicle appeared to be in a vehicle based on the floorboard. The firearm sitting on lap, the black rubber bands on the grab. That one clearly states it's a 6-hour pistol. You can see it in the video or in the photograph. Holding the magazine out of the magazine was empty. He's holding the magazine with ammunition. There's a bag of marijuana. And the caption too was something to the effect of at my kid birthday.
Just to be clear, you see Mr. Arham's face in the video at all? Or post? I don't think it's a video. No further questions, Your Honor.
Can they redirect?
Just briefly, Your Honor. During cross-examination, it had been mentioned that weapons were found during the search. To your knowledge, was one of those weapons lined up with the firearm that was seen in that video?
Yes.
And what weapon was that?
Is the we covered a black 6-hour pistol that had black rubber bands on it.
And you were not the one that found that, correct?
Correct.
Okay. Thank you. Nothing additional, Your Honor.
Thank you. You may be excused.
Yes, Your Honor. People call Deputy Andrew Kerrigan to the stand.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Now, state your first and last name and spell both.
Andrew Kerrigan, AndrewKerrigan.
Thank you, Your Honor. Deputy Kerrigan, how are you employed?
With the Eaton County Sheriff's Office,
How long have you been working with the Eaton County Sheriff's Office?
approximately 2 years.
As part of the Eaton County Sheriff's Office, do you work with BCI here in Lansing?
I do.
Were you working with them on October 30th of 2025?
I was.
In what capacity?
As a undercover officer working as a deputy with Eaton County, but embedded with BCI.
Were you involved in a search of a home through a search warrant on that day?
I was.
What is the address of that house?
615 Moores River Drive.
And what were you searching for as a result of that search warrant?
Primary focus was a firearm that was seen carried concealed on a social media website. It was a black SIG with a rubber band around the grip.
Did you end up finding any firearms inside of that home?
I did.
What did you find?
I found the black SIG P365 matching the one seen the social media video with the rubber band around the grip, and another firearm. It was an older style firearm with a wood grip as well.
Where was this found inside of the home?
In a black tote with a yellow lid. It was in the bedroom on the southeast side of the residence.
Was there anything found in that room to help identify whose room it was?
Yes, there was a green sweatshirt that was also seen on the social media video that the defendant was wearing.
Nothing additional. Thank you, Your Honor. What's his name?
Deputy Kerrigan. We conducted the search at 615 North River Drive. Did you personally locate these weapons that you described?
I did.
Where were they located?
In a black coat with the yellow lid in the southeast bedroom.
How many bedrooms were in this house?
I don't know exactly how many bedrooms were in the house.
You know how many people were living in the house?
I don't know how many people were in the house.
So can you describe to me the layout of this bedroom? What was in it?
Yeah, when you walked into the bedroom, there was a bed in the middle of the room, and then there was a window on the east side, along with a closet next to the window, and the tote was resting underneath the east side window.
Did you only search this room, or did you search other rooms in the house?
I only searched that room.
Are you aware if, I guess, do you know if other rooms were searched?
They were.
So in other words, this was not a search of that specific room by design?
No, it was a search of the entire residence.
You mentioned I think, a hooded sweatshirt, is that right?
Correct.
Did you locate any other items that would indicate who, I guess, was in control of that room or slept in that room?
I did not. I personally did not locate any other items that control that room.
Did you locate any items that might suggest there was more than one person sleeping in that room, or it was, I guess, not one person's full time that was switching off, or anything like that?
I did not.
Aside from this search, do you have any other involvement with the investigation of Mr. Arming?
I do not.
So were you called in just to assist with this search, essentially?
Yes, I happened to be working today that the search was conducted.
Were there a number of officers involved in the search?
Yeah, there were multiple PCI officers and MSP troopers.
No further questions.
No to redirect, Your Honor.
Thank you, Deputy Kerrigan.
Thank you.
Call your next witness.
At this point, the people rest, Your Honor.
or is the defense calling them?
Defense
I'm
for
calling
this.
witnesses. You can read the arguments.
Yes, Your Honor, thank you. As this is a crime involving carrying concealed weapon, a felony, as we had a preliminary examination today, and I asked that you bind over on the carrying concealed weapon charges. The elements for that crime can be found in Michigan Criminal Jury Instruction 11.1. There are two elements for this crime. First, that the defendant knowingly carried a pistol. You heard from Officer Ellis that back on October 23rd, 2025, he was doing an investigation of the defendant's social media. While doing that investigation of the defendant's social media, he ended up finding People's Exhibit 1. As you saw in that video, Your Honor, that was a video of a masked individual. However, it was posted on the defendant's Instagram with all of his photos. There was a timestamp there of 3:09 p.m. There was an additional timestamp that showed that the video had been posted around that time, and then the time the officer himself actually saw the video. There was also a location on that video that was the Citgo King gas station in Lansing, Michigan. You had heard from Detective or Officer Ellis that he ended up doing an investigation where he looked into the Citgo gas station that was closest to the defendant, that being at 500 West Mount Hope Avenue. And while searching that gas station, found the same exact lights that were distinctive lights, and the ceiling were the same as that was in that video. Additionally, Your Honor, you heard that the defendant was on GPS tether at that time. And while contacting JSG, the GPS tether showed that he was less than a block from the incident at the time that was listed in the video. You also heard from Officer Ellis that in his training and experience, these GPS satellites are not approximate. So it was less than a block away. However, it's due to the GPS tether not being exactly proximate. So it's based off of all of this evidence, Your Honor, based off of the additional Facebook posts where on this same exact social media, and also on the Facebook, because that video was also on the defendant's Facebook, another photo of the defendant with a gun. And then additionally, Your Honor, there was a search done of the defendant's home that was stated to be his home on the JSG, and is a location that he was the most prevalent in according to his GPS location. That being the 615 Morse Road address. And while searching that residence, they came across a bedroom. Inside of that bedroom, Your Honor, was a sweatshirt that matched the sweatshirt seen in the social media video, a distinct green hoodie sweatshirt. You also heard, Your Honor, that while searching that room, Detective Kerrigan ended up finding a Sig Saucer pistol, being near identical to the one that was inside of the video, and was identical to the one, seemingly identical to the one that was posted on the social media the next day with the rubber band on it, Your Honor. Therefore, based on all of this, I believe there is probable cause to show that the defendant knowingly carried a pistol at that gas station on October 23rd, 2025, that gas station being in the city of Lansing, Ingham County, state of Michigan. Second, Your Honor, is that the pistol was concealed on or about the person of the defendant. You can see in People's Exhibit 1, Your Honor, and I can play it again for you if you want to. The defendant pulls the gun outside of his jacket and then puts it back inside of his jacket, showing that he was concealing the pistol on his person. So I believe that we have met these elements, and I ask that you bind over on the charges. Thank you.
Mr. Rowley.
Your Honor, there's a couple of issues here. Of course, one of the elements of this crime is that the defendant must knowingly carry a pistol. Pretty simple. In this case, the officer acknowledged there's not enough in that video to convince him or to prove that what we see is a genuine pistol, a genuine firearm, some kind of replica or toy. He said he had an idea of what brand it looked like. It kind of looked like a Sig. I don't know. Frankly, I would want more to convince me that that is definitely a pistol that he's carrying. The officer also acknowledged there's no indication that a crime was committed at that location on that date, or that that pistol, if it is a pistol, was used in any sort of crime ever. Tying the gun to, if it is a gun, to Mr. Arheem. Okay, there's a search of the house. They find a tote with a couple of weapons in it in a room. The only thing tying Mr. Arheem to that room is really a lot of circumstantial evidence. There's a sweatshirt and some other items. Officers acknowledge there are multiple people living in that house. They don't know if more than one person shared that room. If my client was the resident of that room, you know, every day, if they maybe switched out, we do know he had another residence listed, I believe, with pretrial services. So he had more than one home essentially. With regard to the timing of the video, I think that's important. There's a timestamp on it, just 3 something. I don't remember the exact time, but certainly that is a filter that a person can add to a video. It might indicate when it was posted. I think there's a thing that said like 39 minutes ago, indicating when it was posted. It doesn't tell us when it was filmed. It could have been a month ago, a year ago. We don't really know. There's a lot of assumptions going into this, a lot of circumstantial evidence. Frankly, I don't believe the state has shown probable cause that my client, going back to the elements, knowingly carried a pistol, genuine pistol, and that he concealed it as a person. So I'm asking that this charge be dismissed.
Okay, Mr. Arheem, today was the date that was set for your preliminary examination on one count of carrying a concealed weapon. The prosecution is the one that has the burden to establish that they have sufficient probable cause that the felony of carrying concealed weapon took place, and the burden of probable cause that you were the person who committed said act on the date and time in question. The prosecution, however, does not have to establish at this time each element beyond a reasonable doubt. It's just more than mere suspicion. It can be based on circumstantial evidence, but it's just not the same burden that would need to be met if this matter were at trial. We've already gone over the elements. That's carrying concealed weapon. First, the defendant knowingly carried a pistol. It does not matter why the defendant was carrying a pistol, but to be guilty of the crime, the defendant must have known that he was carrying a pistol. Second, that the pistol was concealed. On or about the person of the defendant, complete invisibility is not required. A pistol is concealed if it's not easily seen to those who come in ordinary contact with the defendant. We had testimony from First Officer Jake Ellis from Lansing Police Department testifying that on about October 23rd, 2025, he was working in conjunction with BCI and that he had been monitoring social media, particularly, he says, the social media of the defendant, George Arheem. He indicated that he had some prior knowledge of the defendant, and it's also customary, I guess, that law enforcement is searching certain people's social medias. And so as he was monitoring the social media, he went through the defendant's social media, or the social media that he is identifying as the defendant, and he states he's identifying as the defendant's social media because that social media has several pictures posted of the defendant on there. That there was a video with which the people have presented and showed as People's Exhibit 1, and that it showed the defendant or someone that the officer is assuming is the defendant posting a video with him with some cash in his hand and a firearm. There is again a filter and or some language on the front of the video. In the video, the firearm is not immediately visible. Then the firearm is, or what is purported to be a firearm, is pulled out of the pocket of the jacket. The person in the video is also wearing a ski mask. The filter or the information on the video does put a timestamp on there, 3 something in the day, and then there was also a Citgo King in Lansing, Michigan. Officer Jake Ellis testified that he was also at the time aware, or even maybe ran some information to confirm that the defendant had an active case for an attempted murder, and that he also had been the subject of some prior investigations, it seems. But at the time that he was out on bond and was not to be in possession of a firearm. He also was on GPS tether, and so officers contacted JSG to provide information about the defendant's whereabouts, to which it ironically placed him within less than about a block from where the Seiko King was. Pretty substantial circumstantial evidence there. And then because of that, the officers the officer said he saw at least the next day another picture on social media, which showed the defendant to be in possession of a firearm. So based on that information, he was able to secure a search warrant for the defendant's home. It's unclear how this would be the particular home that the defendant was staying in, especially if the defendant had given a different home address for the purposes of his bond or to pretrial services. I will say that even in this file, I have at least 3 addresses for this defendant, so who knows exactly which home, but it sounds like he might have been between 1 or 2 homes. Unclear about that, but for some reason, the officer believed this to be the defendant's home. The search warrant was executed. There was, during the search warrant, a recovery of a green sweatshirt in People's Exhibit 1. The subject is wearing a very peculiarly colored green sweatshirt, hoodie, and supposedly during the execution of the search warrant, they found said such sweatshirt or one that looked just like that, and located in a room that they believe to be the defendant's room based off, I believe, some medication or other items that had the defendant's name on it in that room. Officers also uncovered or recovered 2 firearms. One firearm, which the officers described to be significantly similar to or almost identical to the firearm or the device they're purporting to be a firearm that was pulled outside of the subject's jacket in the video in People's One, as well as another firearm that was recovered. The defense is arguing that the people have failed because we don't know, based on that video, whether or not that is in fact an actual firearm. Agreed, we don't know. Sounds like it's a question of fact, because it could be a real firearm or it could be a fake firearm. And the information that supports that this could be a real firearm is that when the search warrant is executed, they recover one that looks just like the one he pulled out, but it's actually real. So now the question is this the defendant's actual bedroom or where he was keeping his things? If there's his sweatshirt, and medication is there, and then if this is the same device, I think there's a lot of circumstantial evidence that would support that. So the court is satisfied that there's sufficient probable cause as to count 1, carrying a concealed weapon, that will be bound over to the circuit court for a bind over date of February 25th. Mr. Arheem does not need to appear in the circuit court on February 25th. That's the date the circuit court's going to receive this file. Do you understand that, Mr. Arheem?
Yes.
Your next court date will be a pre-trial in circuit court. Your attorney will be made aware of that. Do you have any questions at this time?
That would be over Zoom.
Your pre-trial over at circuit court, I'm not sure how that's going to be handled. Your attorney will be made aware as to whether or not it's going to be in Zoom or in person. If you're in custody, I believe, until August, correct?
Right.
And so if it's in person, you'll be rated. It's likely it may be a Zoom here, Polycom for a pre-trial. But your attorney will make you more aware as time progresses, okay?
Yes.
Let's see here. On that, with 1,000 cash shorty, will continue. Any additional matters for the record?
No, Your Honor, thank you.
No, Your Honor.
Thank you. You're all set.